On the 8th of January 2024, the trial of OUSMAN SONKO, former Interior Minister of the Gambia, accused of crimes against humanity, will open before the Swiss Federal Criminal Tribunal in Bellinzona. For the first time, a former member of a foreign government is being tried before the national tribunals of a third country based on the principle of universal jurisdiction. My name is Philippe Currat, and I'm OUSMAN SONKO's defense counsel. The exercise of universal jurisdiction is not a matter of international law, but of purely domestic law, each state deciding to which extent it decided to expand its jurisdiction over acts without any form of connection to its territory or its nationals. In Swiss law, the scope of universal jurisdiction is governed by Articles 6 and 7 of the Swiss Criminal Code. Article 6 applies to crimes committed abroad and prosecuted under an international convention or agreement, such as the United Nations Convention Against Torture and other forms of cruel, inhuman, or degrading treatment or punishment, or the Rome Statute of the International Criminal Law. Article 7 deals with other crimes committed abroad and stipulates in particular that where the perpetrator is not a Swiss national and the crime or offense has not been committed against a Swiss national, prosecution is only possible in Switzerland if the extradition request has been rejected for a reason other than the nature of the act, or if the perpetrator has committed a particularly serious crime proscribed by the international community. In the first case, the exercise of universal jurisdiction in Switzerland is subject to two cumulative conditions under Article 6 of the Swiss Criminal Code. First, that the act is also punishable in the state where it has been committed. That's the very classic principle of double criminality. Secondly, that the perpetrator is in Switzerland and has not been extradited. In the second case, Article 7 of the Criminal Code lays down the same cumulative conditions for the exercise of Swiss jurisdiction, adding that the perpetrator must be in Switzerland or be handed over to Switzerland as a result of the act, and that under Swiss law, the act may give rise to extradition, but the perpetrator must not be extradited. These two provisions are supplemented by Article 264M of the Swiss Criminal Code, which deals with the acts committed abroad described in Titles 12 bis and 12 ter of the Swiss Criminal Code, namely war crimes, genocide, or crimes against humanity. And that article states that anyone who commits one of these acts abroad is punishable if he or she is in Switzerland and has not been extradited or surrendered to an international criminal tribunal whose jurisdiction is recognized by Switzerland. To date, there has only been one decision on the merits handed down by the Federal Criminal Tribunal in a case concerning acts committed in Liberia in the mid-1990s. The judgment handed down by the Court of First Instance convicting the accused of war crimes has been supplemented on appeal by an additional conviction for crimes against humanity. The reasons for this decision are not yet known, and it will no doubt be appealed to the Federal Court. In other words, there is as yet no definitive precedent in Switzerland for the exercise of universal jurisdiction, and its limits are still being tested.